In 2022, Senator Ted Cruz clashed repeatedly with Senator Durbin, the Democratic chair of the Senate Judiciary Committee. Cruz, a hardline Texas Republican, did not shy away from controversy or direct confrontation, and Durbin often refused to take it. Their skirmishes occurred across a range of hearings, from Justice Ketanji Brown Jackson's confirmation hearing, multiple witness grillings, nomination interviews, and even in business meetings when pending legislation is discussed among lawmakers. Cruz's fiery moments in the Judiciary Committee often went viral, with some critics accusing him of deliberately engaging in conflict in order to bolster his political brand with conservatives.
Booker was talking about when he said 17 times the same thing happened to Democratic senators under President Trump as you are suggesting happened to you under President Biden. Senator Cruz.
Mr. Chairman, my understanding of the Trump administration is their practice was consistent with how you described their practice with you, which is that they engaged in consultation with Democratic senators, but they did not have an absolute veto.
I might have been an exception, but Senator Booker suggests that in his case, neither he nor Senator Menendez had anything like that relationship with the Trump White House.
I know that the Trump administration in states where particularly you had two Democratic senators, and that occurs where you have state senators from an opposing party, that the process was slower, and there were times where they were frustrated and ultimately did not go with the senator's choice. But my understanding is that the consultation was commonplace. I just wanted to ask a clarification, and I appreciated that you apologized to the senators from Tennessee for the blue slip, and I was not here for the early part of the hearing, so you may have clarified this and I didn't hear it. But my understanding is that the blue slip was sent to the Tennessee senators 6 days ago after the hearing had been noticed, that it was emailed on January 6th, but that the blue slip was backdated to November 22nd. And I wanted to ask, is that understanding correct? And if so, why would it have been backdated?
I don't know. And I accept full responsibility. That isn't what I do every morning, is send out emails and blue slips, but I accept full responsibility as chairman. All right? Senator, we're on a roll, and we're on a roll.
Yes, thank you. I apologize.
Mr. Chairman, before we break, if I could ask one question of the chairman.
Sure.
Senator Hirono just made reference to the recommendations of the probation office in 5 of these cases. To the best of my knowledge, those probation recommendations are not in the record. I haven't seen them. My staff hasn't seen them. And that raises 2 questions. Number one, whether the White House is providing differential material on this nominee's background to Democratic members than Republican members, because I don't know where Senator Hirono would get access to them other than from the White House. But secondly, regardless of whether it's differential, would the chairman agree that there is considerable focus on these cases and the committee, both sides, should have access to the pre-sentence reports and to see the underlying facts? Judge Jackson has said she was following the facts and the factors in those cases.
Senator, you know we've completed discovery before we started this hearing.
Mr. Chairman, how did Senator Hirono get those information that Republicans have not been given?
I'm not going to entertain this. We've been through discovery.
Do you have access to them?
I don't know that I do. I really don't.
Can we ask Senator Hirono how she got access to them?
I'm sorry to interrupt you, Senator, but I want to make an announcement. We're going to have a 10-minute break. Members are going to head to the floor.
So you're going to keep differential access to this information?
I'm not sure what differential access is. I'll look it up. We have a vote on the floor to take about 10 minutes, so 10 to 15 minutes, relax. And then we're going to come back, and we have 2 senators, Cotton and Booker, who will be recognized and then take a break for dinner. And then we're going to try to still finish tonight with 2 remaining senators, Senator Ossoff and Tillis, who are going to be first thing in the morning. So we stand in recess.
The suggestion that I did.
Are you suggesting the number of images doesn't matter? Because you say it in court over and over again that the number of images doesn't reflect that it's a more serious crime. Do you really believe that?
Senator, as I said to Senator Graham, the court is taking into account a number of circumstances. The commission has done a report about the operation of the guidelines, which enhancements actually reflect different levels of culpability with respect
to...
So
let me ask you this, Judge. You've said the purpose of sentencing is to distinguish between crimes that are not as serious from truly egregious crimes. Is that right?
No, Senator.
So what is the purpose of sentencing if it's not to distinguish from less serious crimes from truly egregious crimes?
It is to assign proportional punishment. It is to do justice in cases where you have defendants who are convicted of the same conduct but have differing levels of culpability.
Well, I will point out that you have a pattern. It doesn't matter how egregious the case is. Senator Hawley talked about the Hawkins case where you had an 18-year-old with pictures of boys as young as 8 being sexually assaulted and raped, and you sentenced him to just 3 months in jail. And I will point out the Stewart case, the last one on this list because we're running out of time. The Stewart case, you describe that he had over 6,700 images and videos. So that's a lot, 6,700. That's a lot of kids being sexually assaulted. You have taken over a minute of my time, Mr. Chairman.
You've been given extra time. You usually ask for it. You're given it.
Okay, I know you want to interrupt. I know you don't like this line of
I just want you to play by the rules.
I know you like to interrupt, but you've consumed a substantial
rules,
time of my questioning, and I'm going to ask my questions, and you can, if you want to testify, you're welcome to.
Senator,
Judge,
you play by the same rules as every other senator.
In the Stewart case, you said from the bench, thus, although this is not necessarily an atypical case, your child pornography possession crime was egregious in the court's view. Okay, so this is a bad one. If you're actually sentencing defendants, you said this was egregious. What did you sentence Stewart for? The guidelines said 97, 121 months. Prosecutor said 97 months. You said it's egregious. 6,700 images. You come in with 57 months.
Time has expired.
Why
Senators
did you
use 2 minutes
sentence him
over
to
the
just
allotted
57 months in the Stewart case? Do you want to address that? Because you're claiming it's cherry picking. In fact, you're welcome to explain any of these cases, but let's take the Stewart case. Why
Senator Coons,
did you sentence him for half the amount?
you're not recognized, Senator. Senator Coons.
You don't want her to answer that question?
You wouldn't allow her anyway.
Mr. Chairman, she may answer the question. I've asked her why she sentenced Stewart.
You've gone over the time, Senator, by 2 minutes.
Why she?
and a half.
Because you've interrupted me for 2 minutes, Mr. Chairman. Will you allow her to answer the question, or do you not want the American people to hear why, with someone she described as an egregious?
There comes a point, Senator, where you get a little bit.
Chairman Durbin, will you allow her to answer the question?
You won't allow her to answer.
I will happily allow her to. The question is
Senator
why
Cruz, you may
did
proceed.
you sentence
Chairman.
Stewart, an egregious child pornography possessor,
So,
to
Judge Jackson.
half of the amount
Please, Senator.
requested by the prosecutor?
Please, Senator.
Will you allow her to answer the question, Chairman Durbin?
Senator Coons.
Thank you.
Why are you not allowing her to answer the question? There's
You're
not
over
another
the time
senator
by
here
2.5
that you've not allowed her to answer the question.
You're finished.
I'm not asking another question, but allow her to answer the question, Chairman Durbin.
Thank you, Chairman
Why
Durbin.
do you not want the American people to know what happened in the Stewart case or any of these cases? Chairman Durbin, I've never seen the chairman refuse to allow a witness to answer a question. You can bang it as loud as you want.
Well, I can just tell you, at some point, you have to follow the rules.
Okay, will you let her answer the question? You've been interrupting, and by the way, with Senator Graham, it went 10 minutes over. You've
sure
taken
did.
a big chunk of the time. Will you allow her to answer the question?
You've given her.
Why
no
are you afraid
opportunity
of
to
her?
answer
She's
this.
welcome to answer it right now. Will you let her?
Senator Coons.
Will you let? So no, you don't want her to answer the question?
Senator Coons.
Will you let her answer the question?
Chairman Durbin.
Apparently,
Judge
you are
Jackson.
very afraid of the American people.
Committed. And so judges are having to decide, how are we going to deal with the penalties and do our jobs to impose sentences that are sufficient but not greater than necessary under these circumstances?
Yep. Thank you, Judge. I'll just say in closing that I appreciate that answer, and I understand that as a policy matter. I just think we disagree. I think that the more images are there, the more punishment there should be, and I want to see this deterred. And I just think we've pretty fundamentally disagreed. I've enjoyed our exchanges. Thank you for your candor, and I appreciate it. I just disagree with you on the law. Thank you, Mr. Chairman.
Senator Hirono.
Mr. Chairman. Mr. Chairman.
Senator Hirono's turn.
Mr.
Thank you,
Chairman,
Mr. Chairman.
I'm asking to be recognized to make a point to the chairman.
Mr. Chairman.
I believe he recognized me. May I
Mr.
proceed?
Mr. Chairman.
Mr. Chairman, I waited my turn on here, and I've been on this committee for 47 years. I think we ought to follow the regular order.
Mr. Chairman, the witness just said that we cannot understand those
I'm
cases
sorry,
without
Senator.
the pre-sentence
I
reports.
don't want to go through this again.
I have a letter that I want to enter into
There
the
are rules
record
in the
that's
committee
signed
that
by
should
10
be
senators
followed.
on this committee. Are you not even going to allow a letter from 10 senators on this committee?
Send any letter, you can do it by
This
hand
letter
or by
that is
mail.
signed by 10 senators on the committee addressed to you makes the point that the White House gave you probation information for Democrats that was not provided to the minority on this committee. And just now, Judge Jackson told Senator Hawley, you cannot understand these cases without reading the probation reports. 10 senators on this committee are asking the chairman
Mr. Chairman,
to provide those reports so we can do what Judge Jackson
Mr.
just
Chairman,
said, which is to
know
assess
the-
those reports. And
Mr.
here is the
Chairman,
letter.
I know
I
the
ask
ju-
unanimous
I know the
consent that it
junior
be admitted to
senator-
the record.
I know the junior senator from Texas likes to get on television, but most of us have been here a long time trying to follow the rules. And he could very easily hand you a letter to go in the record. He's saying he's doing this to help Senator Hawley. Senator Hawley could have put it in, and he didn't. Let's get back to regular order.
Senator Hawley
God's
didn't
sakes.
write the letter. Mr.
Let's get
Chairman, I
back to
ask
regular
unanimous
order.
consent that it be admitted to the record.
Senator Rono.
Thank you.
Are you denying consent?
Thank you, Mr. Chairman. Aloha, Judge Jackson.
Aloha.
Thank you very much. Before I recognize Senator Padilla, I obviously want to correct the record from something that's been previously said about a previous nominee, Justin Walker. First, I think it bears noting that this nominee, Mr. Garcia, has an extensive record. Though only 36 years old, he has been an appellate advocate and eminently qualified, argued 13 cases before federal and state appellate courts, including one before the U.S. Supreme Court and another 10 before federal circuit courts, represented clients in over 50 cases before the state and federal courts of appeal. Supreme Court alone, he's briefed 10 merit stage cases and another 8 cert stage cases. The nominee, Walker, that Senator Cruz referred to, it is true, was 2 years older when he came before us. Walker had assisted with the briefing in only 4 matters before the Supreme Court, and he was not listed on a single filing. He'd also never served as sole or chief counsel in any case tried to verdict of judgment, and served as associate counsel on only one federal criminal jury trial. It is true that both nominees have different backgrounds, but to suggest that this nominee is not better qualified, I saw it differently. People are entitled to their opinion. Senator Padilla.
Thank you, Mr. Chair.